I'm personal injury attorney Jeff Adelman. I want to talk about settlement demand letters. Most of the time, prior to filing a lawsuit, an attorney will send a demand letter to the insurance company to try and get the case resolved. There's really two types of demand letters. Ones where there's inadequate policy limits, inadequate funds, and two, when a patient has finished treating. We're going to start first talking about the inadequate limits. This involves a serious injury with not enough insurance coverage. As soon as it becomes obvious, such as if there's only a $10,000 policy of liability coverage with an injury such as a fractured wrist, I send a letter out, and there's several reasons for doing that. The first one is, if that's all there is, you might as well go and get it. You don't want it sitting in the insurance company's bank account. Now, prior to accepting these policy limits, we usually do an asset search to make sure that the person who caused the injury doesn't have anything that would be attachable, anything that we could force a sale of in the event of a judgment. But most of the time when you're dealing with somebody who has a $10,000 policy for liability, they're not going to have attachable assets. So that's something that you have to consider. And when people say to me, well, can you go after the person for more than the policy limits? Well, I always tell them there's a reason that O.J. Simpson moved to Florida, and it isn't because of the weather. To try and get assets from somebody in Florida is very, very difficult. There is the homestead rule in Florida, which basically says you can't force somebody to sell their home because they owe a money judgment. Florida is one of the best states for protecting your assets in, and people who owe others money certainly know that. Now, when you send out an inadequate policy limit letter, you're also looking at bad faith. Now, bad faith is something that involves an insurance company not acting in the best interests of their insured when a reasonable insurance company would do so. For example, if somebody is going to be out of work for 6 months and that is going to way surpass $10,000 on the subject policy, it's very obvious that the insurance company should offer the money for their insured. So that's why you do that. Now, if they don't offer the money, then bad faith comes into play, and there's the possibility of actually getting more money than the policy limits of the person that hit you. If the insurance company doesn't act right by the victim, then they could be on the hook for the entire judgment a jury were to give a plaintiff. So it's very important to give the insurance company an opportunity to do right. But if they don't, then we're talking about potential bad faith. Now, a normal demand situation would be when a client finishes care and treatment from an accident. Now, that's in the best interests of everyone. If there are adequate policy limits, you send a demand letter where you summarize the care and treatment of the victim, and you give the insurance company an opportunity to make a reasonable settlement. That's just the right thing to do for everybody involved in the matter. If the client can get the case resolved without having to have a lawsuit, that's a good thing for them, good thing for the attorney, good thing for the insurance company. Doesn't always happen, though. But generally, what I tell patients and clients is that it takes a good 4 to 8 months after an accident or a slip and fall incident to know whether or not a case is going to be resolved. Now, obviously, that can be different if there's a surgery, but without surgery, generally we know where we're going in 4 to 8 months. And if the negotiations hit a standstill and we can't get the case resolved, the next step would be for the attorney to draft a complaint and file a lawsuit. And I'll talk about that in the next episode. Again, I am Jeff Adelman. I can be reached at 954-341-2777 or go to my website, adelmanlawyers.com.